Welcome back to the Legal Roundtable debate here on the Oscar Pistorius Trial, a Carte Blanche channel. And now, our legal experts for the night. I have Attorney Tyron Maseko, former Zimbabwean High Court Judge, Chris Greenland, and Defence Attorney Ulrich Roux. Your first time, gentlemen, on the panel. Since the break. Thank you very much for your time. We have had quite compelling evidence today. I found it very interesting, but I think my first question, I'll start with you, Tyron. Where's it going? What was the defence trying to achieve with this testimony of Professor Wayne Dermans?
So the way that I see it is that, if you consider the fact that Oscar Pistorius is charged with murder, premeditated murder, but we know that a competent verdict on that is culpable homicide. So the defence is...
Let's just explain the competent verdict.
Okay.
So if he is acquitted on the charge of murder...
Correct.
The judge then considers a charge of culpable homicide. It doesn't have to be specified on the charge sheet. It's called a competent verdict.
Correct.
Okay.
Correct. And so, because the defense is wary of this fact, that then means that while they're presenting evidence on this murder charge, they also have to be cognizant of the fact that even if Oscar Pistorius is not found guilty on murder necessarily, the court could still apply the principles for negligence to find him guilty on culpable homicide.
Okay.
And so they then have to present evidence which, if you like, sort of ameliorates that risk, that negates that possibility of a conviction. So they need to get that
on the record.
Correct. And if you think about culpable homicide as simply being negligence, failing to live up to a standard of a reasonable man, then you'd understand why they're presenting this evidence, which really goes to, well, Oscar Pistorius, you apprehended danger, as you put it. We don't accept that that is the case, but that's your version. Let's work with that. You thought that your life was in danger and that of your girlfriend, and you had a choice of how you were going to react in that situation. You could have taken the part of least resistance. You could have actually avoided killing someone else by fleeing, quite frankly. You chose not to. You approached the danger. Why? And that is why they're dealing with this aspect of, flight or
okay, so they're bolstering a case for the objective test, and we'll go into what that means, and the reasonable man, and now possibly the test of the reasonable disabled man. Ulrich, where do you see this evidence going? Why are they injecting this evidence?
I agree with Tyron, David, and I think we need to go back to Oscar's plea and his plea explanation when the trial started.
Yes.
And that was that he knew what he was doing at all times when he fired the gun, but that he made a mistake.
Right.
Now, when you make a mistake, it says that you were negligent. Now, as Tyron pointed out, the reasonable person test needs to be applied, the bonus pater familias. And that says that a level of adequate and consistent care is required of a person when acting, and when that reasonable test person is applied. Reasonable person test is applied. Now, I think that the defense is leaning towards the reasonable disabled person test. Now, it is not a...
We don't have that in our law.
We don't have it in our law, but I firmly believe that this is the sort of direction that Oscar's counsel is pushing this witness in order to argue at the end of the day and say that, well, listen here, since the outset of this matter, and since evidence has been led in this matter, we've always said that Oscar has been influenced his entire life by his disability. He's always been this person who has been susceptible to ridicule and to people teasing him, and he would be in danger if confronted with a dangerous situation or a violent situation. And because of that, and this whole flight or fight scenario, that is exactly the reason why he acted the way he did. That because of his disability, he would rather fight and go towards something than rather fleeing. And, at the end of the day, the judge is going to decide whether she accepts that or not. One also needs to consider, of course, is did he apply the principles that was expected of him when acting in self-defense to determine who was behind that door before he shot the 4 shots.
And that's a subjective test.
It is exactly. And the reasonable person test there does not come into the equation at all.
They might be bolstering the argument for the objective test, should it go to the competent verdict of culpable homicide. But Chris, are they not injecting this evidence because on the subjective test, it is important for the judge to consider those aspects that are so different to other people that influenced Oscar Pistorius. So when she decides this on the subjective test, she's looking at Oscar Pistorius as Oscar Pistorius, the disabled man.
True, and I do support what my colleagues have said, but true, because if Oscar is to be absolved completely, as Tyrone has said that the probability is a verdict of culpable homicide, then the court will have to discard the test of reasonableness, because at the heart of the facts is his advancement towards the perceived danger, towards the door, at which stage, as a reasonable person, he could see that there was no danger. He could see that he was not under imminent threat of injury or death. And then he goes forward and shoots through a closed door. All that is unreasonable. So I agree with my colleagues that if he is to be acquitted, absolved of everything, then the court's going to have to abandon the test of reasonableness, which is at the heart of our law. But to answer your question, I think as regards the charge of murder, what I've just said also applies.
Yes.
I think the defense are on an uphill problem here, because for that very, very reason, in order to absolve Oscar, the court will have to accept that it was not unreasonable for him as a disabled person not to perceive the obvious,
yes,
not to see that there was nothing in front of him, not to see that he was not under imminent threat of injury or death. And I think that that is a tall order.
But also on the issue of Oscar's version of events, if the state wants to show that that version is not reasonably possibly true, the defense is trying to show that those actions that appear not to be reasonable are in fact in Oscar's case reasonably possibly true. That seems to be critical evidence to go to that.
David, you'd be then setting a standard for disabled people which is simply not reasonable.
Yes.
That's what you'll be saying. You'll be saying that disabled people are just not reasonable. You can expect...
Or a different level of reasonableness, Chris?
Well, it's not reasonable that you cannot appreciate what your eyes are telling you. It's simply not reasonable. So...
Not reasonable to be more startled than another person, that you have a heightened sense of anxiety than other people.
No,
isn't that reasonable?
Whether it's self-defense or whether it's putative self-defense, you have to be under threat of imminent injury or death. When it's self-defense, it's actual. Yeah. When it's putative, it's imagined.
Yes.
Okay. So for Oscar to be cleared, then the court would have to set a standard saying, but this doesn't apply to disabled people. They are not required to be reasonable.
I think many disabled people actually took exception to today's testimony.
I saw that on Twitter, yes.
Because he stereotyped completely Wayne Derman. He said that, well, all disabled people are more susceptible to ridicule and to be more in a more vulnerable situation when faced with danger or violence. And I think people took exception to that because, as Judge Greenland says correctly, you cannot just apply this across the board to everyone. It applies to every single set of facts, this test, and to every single person. And did he act reasonable in that scenario, as was expected of him as a reasonable person?
So should we then not, if a case of culpable homicide is to be judged here, in fact, I'm going to get, let me pose the question, I'm going to get you to answer it after the break. If we are going to then say there is the test now of the reasonable disabled man, which we don't have in our law, my question to you when we come back from the break is, should we have such a test? We raise the standard. If it's a heart surgeon who's committed culpable homicide, he's judged according to the reasonable heart surgeon. Do we do it the other way and say there is such a thing as the reasonable disabled man? So I'll ask you that after the break. You can join us on Twitter, on Facebook, on Instagram, and WeChat. Search for Oscar Trial 199. A little later in the show, we'll be looking at your tweets. We're back after the break.
how to get a little extra out of your DSTV viewing and keep the whole family happy. DSTV Extra View allows you to link 2 Extra View capable decoders under a single subscription and watch 2 different channels on 2 different TVs at the same time. For more info about Extra View and which decoders are Extra View capable, go to dstv.com. DSTV Extra View, another little added extra worth smiling about.
Calling all Durbanites, it's time to get ready for foodie heaven, because the Pick and Pay Taste of Durban is back from the 25th to the 27th of July. To celebrate this gourmet extravaganza, DSTV is giving 100 lucky premium customers VIP tickets to the event, plus throwing in a personal chauffeur, so you can indulge in the festivities without worrying about the drive home. And if that's not enough to whet your appetite, one lucky DSTV couple will also walk away with a year of mouth-watering dining from 8 of Durban's finest eateries. Talk about a sensory overload. To enter, simply upgrade to DSTV Premium, then visit our website and answer one easy question. And if you're already a premium customer, all you need to do is log on to dstv.com and enter. Prepare your taste buds for Durban's premier restaurant event, courtesy of DSTV.
3, 2, 1. Go.
And
Fight! 3, 2, 1. Go.
And
Fight! 3, 2, 1. Go.
And
Fight! 3, 2, 1. Would you repeat it? 3, 2, 1.
it's a killer mix of Salis action every night at 8 this June and July on Mnet Movies Action Plus and Action Channel 106 and 110.
Go.
Welcome back to the Oscar Pistorius Trial Channel with me, Attorney Tyron Maseko, former Zimbabwean High Court Judge Chris Greenland, and Defence Attorney Ulrich Roux. Now, before the break, we were talking about the concept of the reasonable man. If a competent verdict, if the court has to decide, possibly, and we're using if all the time, if the issue is of culpable homicide, Oscar Pistorius' actions are judged against that of the reasonable man. But is it the reasonable man, or is it, in Oscar's case, the reasonable disabled man? We don't have that concept in our law in South Africa. It would be making new law. Should we be making new law? And that's the issue that I'm asking our panel. But I think, first of all, let's actually delve into this issue of the reasonable man. Who in South Africa is the reasonable man? I remember from the old law textbooks it was the man on the Clapham omnibus. We don't have the Clapham omnibus. Who is the reasonable man in South Africa?
Look, to give a short answer to that is it's actually a fictitious person.
That's
they
right.
don't exist. We make them up as we go along. We try and attribute certain characteristics and sort of a persona to him which actually doesn't exist. We are very careful to make sure that he's not perfect, because none of us are. But at the same time, we expect him to uphold a certain standard which society can accept and expect of all of us, really. So in short, really, that's what it is.
Okay.
But
Can I ask Chris, how many times in your career have you had to apply the reasonable man test? And who in your head has been the reasonable man?
Reasonable man. I was going to say Julius Malema, but I decided that I would say that it's a 70-year-old
Retired judge.
On the Oscar Pistorius panel.
But neither are typical people. So how do you find the reasonable person? If you have got a man on trial and he lives in rural Eastern Cape versus a man who lives in Hillbrow,
you know,
two very different.
On a serious note, an analogous thing, I always said nobody should be appointed a judge unless it's actually been to a shebeen. So to me, a reasonable man is, I think, a 24-year-old born African in this region who attends a shebeen.
Okay. And
I'm going to go towards the legal definition.
I like this, yes. Thank you.
And that says that it goes towards the care aspect. So a reasonable person test in terms of our law and in terms of the Criminal Procedure Act is a person who displays adequate and consistent care at all times. So I agree with Judge Greenland and with Tyron. In a country like us, it just develops continuously because there are so many different people and so many different facets that we are faced with every day in our lives. But the care aspect must still remain.
So we don't need then the concept of the reasonable disabled man, because if you're disabled, it's not about the disability, it's about the reasonableness of your care.
Yes, but the reason why we stated that is because that has been, in my opinion, the defence's angle at all times. That you cannot apply this normal test to this person because he is not normal. He is disabled. So you need to
You're going to
apply.
get the disabled community on your head.
No, but remember, every test that's applied in every case must be seen in context and must be seen with the facts surrounding it and what happened on that evening. So that's why I said I think a lot of people took exception to being stereotyped today in court, because you cannot just do that. It's not a broad test that you apply. It's a test that you apply to a specific person when faced with specific facts.
Okay,
and
so
that
the
is what they need to apply to Oscar.
So it goes directly to the subjective test.
Yes.
Then. So it's vital for the subjective test.
I think one has got to be very careful, David, when we speak of the subjective test, and yes, the test is subjective. And what we mean by that is that, we talk about objective and subjective. Objective doesn't look at what David may be considering.
Let's use Oscar as an example.
Okay.
A much easier example.
Okay. So if it was an objective test, then we wouldn't care about what Oscar perceived. Then, quite frankly, we'd be convicting him already because we know that objectively it was River Steenkamp in that bathroom. That's objective. Subjective is saying, well, yeah, we know there was River Steenkamp in the bathroom, but actually Oscar Pistorius in his head thought, well, that would be his argument,
yeah,
correct?
he says he thought.
Exactly. He thought that it was an intruder. And if he is correct, because we don't convict people unless they have a guilty mind, then you'd have to say, well, then we have to acquit him. This is just dealing with murder for the moment. So when we talk, so how does this reasonable man standard then come into question? What's its relevance? Its relevance is this: it's not good enough that you simply do whatever you want to do just because you've got full conviction in the fact that you are mistaken in your actions. But we still expect you can make mistakes. But as society, there is a level that we set to say, well, this is a mistake that we don't expect of you. A driver, for example, if you get in your car, we expect you to drive cautiously, consider other motorists. So
drive sober.
Correct, in all those things. And that is why I think it's actually the law, that while we consider, we view intention from a subjective point of view, we don't completely ignore objective factors.
Yes.
So those objective factors in this particular case are everything that Oscar Pistorius has told us. So those objective factors are things that you yourself consider in coming to that subjective conclusion. So Oscar Pistorius, we say, well, you just spoken to your girlfriend. There are two of you in the bedroom. It's late at night. You just hear a sound. Could it be that it's your girlfriend? Should you have considered that? And that's where the objective considerations come in. So in summary, really, there are circumstances where it's just not possible for someone to come to a particular conclusion, where we say, look, we're looking at it subjectively, but even you couldn't come to that conclusion, surely, given all the circumstances.
I hope that's clear to everybody at home. Chris, how compelling is this evidence?
The evidence of Derman.
He's the man in the stand.
I think he's made a mistake in that he's playing two roles. He's giving evidence as Oscar's treating doctor.
Yes,
and he's also giving evidence as a forensic expert. And I don't think it's working very well. And I think that he's already running into trouble because of that. And I think that when Gerinel comes back tomorrow, we're going to see... On Monday. We're going to see that, that insofar as he has ventured into the forensic opinion realm, he's going to be in all kinds of difficulties.
So do you agree, has he overstepped his reach there? He's the team doctor. He treated him Oscar as a professional sportsman. Has he overstepped his mark in terms of his level of expertise, Ulrich?
Yes, well, Gerinel certainly tried to make that point, and he brought an application for his evidence to be disregarded by court. Remember, the function of an expert witness is to guide the court and to provide testimony for the court's benefit, because that person is an expert in a specific field. So in that regard, I agree. I think it was dangerous to call him because he has known Oscar for 6 years. He clearly has a very close relationship with Oscar. He's said he was personally involved where Oscar's been through personal trauma and things like that. So I think he has overstepped it. Just on that point, which is an important point and which quite a few people asked today as well, is that can Gerrie Nel now recall someone to rebut his evidence?
Yes.
And he can certainly because he is regarded as an expert, but his report wasn't furnished to the state before he testified. So they could not hand his report to one of their experts in order to provide an opinion rebutting his evidence. So certainly Gerrie Nel could bring an application, and he might do that on Monday after having consulted with Carla Kotze regarding Derman's testimony, and he could certainly bring an application to reopen his case, and I think it will be a compelling application, and the judge, in my opinion, will grant it because he needs to be given an opportunity to rebut this expert evidence, but only because it's expert evidence.
Yeah, expert evidence, and he hasn't been able to challenge that report with one of his own.
Yes.
Chris, you've had
David, just another analogous point which I'm hoping will be cleared up at some time, which I find very interesting. This fight or flight, which is absolutely critical to the defense now, and we're hearing all about it. Apparently the way the brain works, the triggers for rage are exactly the same. So I'm looking forward, I'm hoping that this will be taken up, which would mean that all this evidence that seeks to exculpate Oscar is equally consistent with him having acted out of rage.
Out of rage, okay.
So I think you need to get your expert psychiatrists on this.
And I suppose, Tyrone, that not only will Gerrie Nel be consulting with Carla Kotze with a view to possibly putting her in the stand, but also with a view to saying, have I exhausted my cross-examination? Are there other questions I should be asking of Wayne Derman since he's in the stand right now?
Correct. And I actually think there is a lot that Gerrie Nel can still traverse with this particular witness. I mean, he's made a lot of damning findings against Gerrie Nel's case, which Gerrie Nel will want to deal with. And quite frankly, I'm not so sure actually that this witness is qualified to speak to all these aspects on which he speaks. He's a physiologist. My apologies. No. But a lot of the stuff that he's been talking to actually relate to mental faculties, psychology. So surely we've had psychological reports submitted here. Surely those reports better deal with Oscar's state of mind. I'm not sure that he's actually qualified to talk about everything that he's spoken about, besides the fact that my personal view is that the defense is guilty of calling way too many witnesses.
We'll continue this rather fascinating discussion right after this short break.